Next on our agenda is a discussion of Crowe v. Oregon State Bar and potential implications for mandatory bars. I understand General Counsel Shankland will be leading that discussion. You can find the materials on page 444 of the main materials.
I did not submit materials. There is a PowerPoint that I'm hoping Rex has.
There's a case in the materials.
Oh, just the Crowe case. Okay. Okay. So the purpose of this presentation really is just to update you more about why are we monitoring all of the cases that have been filed against integrated bars after the JANUS decision, and that includes the recent case of Crowe versus Oregon State Bar. So I'll do a very quick summary of the types of bar associations, so we all are using the same words, and then a quick summary of the many court decisions about the First Amendment speech and association rights relating to integrated bars. As you know, integrated bars, and I guess we can go to the next slide now, Rex. So there are three types of bars. There's voluntary bar associations that membership is voluntary and they don't administer regulatory functions. There are mandatory bar associations that membership is mandatory and they may or may not administer regulatory functions, but integrated bars have mandatory membership and they have integrated functions, right? They administer regulatory functions and they perform professional association services. And it's the combination of those two things, the mandatory membership and the integrated functioning, that seems to implicate the First Amendment compelled fees, speech and association rights cases that I'll be talking about. And just because you're all lawyers, I'll just point out that, you know, this is just an overview. It's not intended to be exhaustive. The next slide, Rex. So just before we launch into this case, there's about, typically the number that's cited for integrated bars is 31 states plus the District of Columbia are integrated bars in the US. The first integrated bar was North Dakota. I think that happened in about 1921. And then here we see in 1956, so about 30 years later, is the comparison between unions and integrated bars. So this case, some employees sued the railway company and the unions, asking for an injunction because they did not want the union to enforce union shop agreements, which would require all of the employees, as a condition of continuing their employment, to join and maintain their union membership. There was a federal statute that allowed that. Interestingly, the statute prior to 1951 specifically said that that could not happen. You were not allowed to, excuse me, you were not allowed to have these union shop agreements. Congress said they changed the law based on basically changes in the world. You know, originally there were employer unions in this area and they were being used to prevent employees from exercising their collective bargaining rights. But over time that changed, and as high as 80% of the employees were members of the unions. And then there was the free rider issue where the unions were required to provide collective bargaining right benefits to all of the employees, but only some of them were paying. And the reason I'm talking about that here is that I think we'll see that concept of the courts changing how they think about the impact and purpose of unions showing up again in JANUS. So here, as I said, this was employees suing, and this was in fact before any union shop agreement had been enacted. They were suing because they didn't want to be forced to join and pay for a union. And they claimed that it violated the Nebraska constitutional right to work provisions. And it's interesting because the federal statute specifically and expressly said that it was notwithstanding the law of any state. And so you can see here, the court says that they hold that the requirement for financial support of the collective bargaining agency by all who receive benefits is within the power of Congress under the Commerce Clause and does not violate the First or the Fifth Amendments. So it would be nice to think there was some nice First Amendment analysis to fall back on, but the next bullet is the First Amendment analysis that's in that case. On the present record, there is no more an infringement or impairment of First Amendment rights than there would be in the case of a lawyer who by state law is required to be a member of an integrated bar. And specifically, the court did not address the free speech issue. So that was a decision authored by Justice Douglas, which will become important in a moment. So one point before we go on to the next case. So even here, without a lot of First Amendment analysis, there are hints of the issues that are going to come later, because here the government is deciding to regulate a group of people for public protection, and the unions are arguing that they serve a regulatory function and they're required by law to serve that regulatory function. And some people in the regulated group are arguing that that tramples on their individual rights. So that will come up over and over again. The next two cases, next slide, Rex. So there's another railroad case. Oh, I forgot to mention, we're going to talk about trains and mushrooms today. I hope that's okay. So the next two cases were argued and decided on the same day, which I find to be somewhat interesting. One is a railroad case, another Railroad Act case, and the second one is actually an integrated bar case. And they are intertwined, not only in issues, but also in citing to each other. So, you know, the court is sort of intertwining integrated bars with unions yet again. So this case sort of takes the next step in the free speech issues. So this time, the union shop provisions are being challenged because of the way the unions are actually spending the funds that they receive. The complaint is that they were supporting political causes, and that the members who had paid the money disagreed with. The procedural history here is that the Superior Court in Georgia actually issued an injunction finding a violation, a constitutional violation. However, the US Supreme Court did not decide the case on constitutional grounds. Instead, it interpreted the statute in a constitutionally appropriate way. So it interpreted the statute to make it clear that the union could not spend the money it collected in a way that would violate the dissenters' free speech rights. And interestingly, it talked about remedies, like what should you do if there were free speech violations. So in Justice Black's concurrence, in this case, he ties the two cases, Street here and Lathrop, which is the next case, together, and says the constitutional questions raised alike in this case and in Lathrop are bound to come back here soon. And so, why are we avoiding deciding this issue? He goes on to say that he actually would have found on the record presented a violation of this free speech guarantee of the First Amendment. But again, the court did not decide this case on constitutional grounds. Next slide, Rex. Next slide, Rex. Rex. Oh, thank you. So now we have the first case in this line of cases that actually deals with integrated bars. Some of the justices actually referred to this as a companion case to the street case. Something important to note is this is a plurality opinion. So the facts here, so the Wisconsin bar was integrated for a 2-year trial period in 1957. And then in 1958, that was continued indefinitely. And a member brought a challenge to the dues in the 1959 year saying, I do not like to be coerced to support an organization which is authorized and directed to engage in political and propaganda activities. His complaint also alleged, I want to give you a little bit more detail because, so now we're going to get into the right of association. So what is exactly meant by freedom of association? And that, as you know, I think is an issue in the Crowe decision that we're going to talk about in the end of this. So I want to try to build up to that here and be clear. So his complaint alleged, more specifically, that the state bar promotes law reform and makes and opposes proposals for changes in the laws and constitutional provisions, and argues to legislative bodies and their committees and to the lawyers and the people with respect to the adoption of changes in codes and laws. He alleges further that in the course of this activity, the State Bar of Wisconsin has used its employees' property and funds in active, unsolicited opposition to the adoption of legislation by the legislature, which was favored by the plaintiff, all contrary to his convictions and beliefs. So the circuit court and the state Supreme Court, the circuit court dismissed this case, this challenge, and the state Supreme Court affirmed it. So the US Supreme Court stated that the core of the appellant's argument is that he cannot constitutionally be compelled to join and give support to an organization which has among its functions the expression of opinions on legislative matters and which utilizes its property, funds, and employees, quoting from the complaint there, for the purposes of influencing legislation and public opinion. So regardless of how the plaintiff described what he was asking for, the court here seems to have defined the issue that it was going to decide as freedom of association, meaning compelled financial support for group activities, including speech. So I think that's going to become important later. So here, that was the issue. And you can see, so the court says, we think the Supreme Court of Wisconsin, in order to further the state's legitimate interests in raising the quality of professional services. So note the court now seems to be also starting to follow sort of the expected First Amendment scrutiny here, right? They're looking for a legitimate compelling state interest, and they may constitutionally require that the costs of improving the profession in this fashion should be shared by the subjects and beneficiaries of the regulatory program, the lawyers, even though the organization created to attain the objective also engages in some legislative activity. So, and then further, given the character of the integrated bar shown on this record, in the light of the limitation of the membership requirements to the compulsory payment, we are unable to find any impingement upon protected rights of association. So it's not only did the court sort of say, yes, you can be required, you may constitutionally be required to join and pay fees to an organization that engages in some speech. Sorry, but also it appears that they're starting to become a little more clear that they're actually engaging in a relatively high level of First Amendment scrutiny. So looking for a compelling government interest, and then looking for at least some limitation on the other side, like, more than just a rational basis or reasonable basis. However, they did not rule at all on the protected speech issue, right? We therefore intimate no view as to the correctness that the appellant may constitutionally be compelled to contribute his financial support to political activities which he opposes. So again, I guess there's no explicit level of scrutiny here, but it really is starting to look like compelling governmental interests and least restrictive means. And this decision seems to base the approved associational interests on financial support of group speech. It is a plurality decision, and the only reason I'm actually emphasizing that is because case law and cases continue to rely on Lathrop even today. And probably one of the most interesting things about this decision is that Justice Douglas, who wrote the Hansen decision, where which was where the integrated bar was first compared to unions, says this in his dissent. In the Hansen case, we said, to be sure, that if a lawyer could be required to join an integrated bar, an employee could be compelled to join a union shop. But on reflection, the analogy fails. All right. So in 1956, there was this analogy between unions and integrated bars. In 1961, the author of that opinion seems to have changed his mind. So 30 years go by, and then finally the free speech part of the issue is decided. Rex, the next slide. So this is Keller. I think you're all probably pretty familiar with this case. So this was members of the California bar sued, claiming that bar was using their membership dues to finance ideological and political activities that they were opposed to, and that violated their First Amendment rights. The procedural history here, I want to go through just quickly because it's sort of interesting, at least to me. So the trial court actually granted summary judgment for the state bar. The California Court of Appeals reversed based on a bood, finding that under a bood, it was fine. Sorry, under a bood, such activities could be financed from mandatory dues only if the particular actions in question served a state interest important enough to overcome the interference of the First Amendment rights. And then the California Supreme Court reversed again on the grounds that the state bar was a state agency. and that they could use their dues that they collected for any purpose that they wanted, so long as it was within their broad statutory authority. The US Supreme Court agreed that lawyers admitted to practice in the state can be required to join and pay dues, but disagreed as to the scope of the permissible dues financed activities that the state bar could engage in with those fees. So specifically, they affirmed as constitutional mandatory membership in an integrated bar. They cited both Hansen and Lathrop. The quote is, Hansen and Lathrop surely lays to rest all doubt that a state may constitutionally condition the right to practice law upon membership in an integrated bar association. And then they point out that the Keller case raises the free speech issue that Lathrop didn't address. And I definitely want to talk a little bit here about how much the Keller decision relied on the Abood decision, because as we know, jumping forward, that case later is overruled, which leads to a lot of confusion. So first of all, the court noted that many other courts had applied the Abood analysis to integrated bars. Several federal courts had done so, but the California Supreme Court didn't follow that example. Then the court engaged in some analysis about why the state bar was more like a union than it was a state agency. And it said this: the State Bar of California was created not to participate in the general government of the state, but to provide specialized professional advice to those with the ultimate responsibility for governing the legal profession. And then they went on to say, in contrast to that, so in contrast with the claim that the California State Bar was a state agency, there is a substantial analogy between the relationship of the state bar and its members on the one hand, with the relationship of employee unions and their members on the other. So I don't know what happened in the intervening 30 years where that idea was questioned, but now it's back. And the court went on, it's entirely appropriate that all of the lawyers who derive benefit from the unique status of being among those admitted to practice before the court should be called upon to pay a fair share of the costs of the professional involvement in this effort. So kind of the free rider argument. And further, so yeah, so it's my second bullet here under the decision of Keller here, but specifically the court talked about Abood's language and then sort of tailored Abood's language for the integrated bar situation. So Abood held that a union could not expend a dissenting individual's dues for ideological activities not germane to the purpose for which compelled association was justified, which is collective bargaining. Here, the compelled association and integrated bar are justified by the state's interests in regulating the legal profession and improving the quality of legal services. So, at least in part, I think that sort of tight tie between the Abood decision and Keller leads to some later issues. So then the finding is the state bar may therefore constitutionally fund activities germane to these goals out of the mandatory dues of all members. It may not, however, in such manner fund activities of an ideological nature which fall outside of those areas' activities. The difficult question, of course, is to define the latter class of activities. So the court was admitting that there's an imprecise line for deciding sort of what's in and what's out. There was a description, a lot of description in the Keller case about what was in and what was out. I think I'm not going to address that right now. We can come back to that later if anyone has questions. But for purposes of this discussion, the broader free association claim was not addressed. it would be really nice if what the broader free association claim was clear. But the decision said petitioner's complaint also requested an injunction prohibiting the state bar from using its name to advance political and ideological causes or beliefs. This request appears to implicate a much broader freedom of association claim that was at issue in Lathrop. The California courts didn't address this claim. We declined to do so. So it's not exactly clear, I guess, what this is, but here Keller has stated that there is potentially a broader freedom of association claim than the Lathrop decision, which was financial support for compelled financial support for group speech. Next slide. All right, I threw in this Ninth Circuit case because we're in the Ninth Circuit, and also because when we finally get to the Crowe decision, they, I think, feel the need to distinguish it because they're kind of running over the top of their own decision. So the issue here is whether plaintiffs' First Amendment rights are violated by their compulsory membership in a state bar association that conducts political activities beyond those for which mandatory financial support is justified. And so the plaintiffs here specifically contend that language in Keller left open this question about whether membership alone in a state bar could violate the plaintiff's First Amendment rights. So it seems as though they are, trying to raise this broader issue here. And then, as you can see, the court decided, however, that Lathrop controls. Here, the plaintiffs do not allege that they were compelled to associate in any way with the California State Bar's political activities. They do not allege that the bar's political involvement is greater than the regulatory function, less than it was when the court decided Keller and Lathrop. So Lathrop controls. So it is interesting because this appears to be kind of very close to the description of the free association claim made in the Crowe decision, and the court decided that it was controlled by Lathrop. Next slide. All right, so this is just a compelled fee for funding private speech case involving mushrooms. There was a federal statute that created a mushroom council, and it imposed mandatory assessment on fresh mushroom handlers to fund product advertising. There was a large agricultural business that grew and distributed a lot of products, including mushrooms, and they refused to pay the assessment because they wanted to be able to advertise that their mushrooms were better than everybody else's mushrooms. And in fact, the advertising they were being required to pay for was just all mushrooms are great, regardless of branding. So this case actually does cite to Abood and even to Keller in their decision. And so here, the court said, although they didn't, the court actually said that the statute here couldn't even survive the lower level of scrutiny that commercial speech would get, but it made clear that compulsory subsidies for private speech are subject to exacting First Amendment scrutiny and cannot be sustained unless two criteria are met. First, there must be a comprehensive regulatory scheme involving a mandated association among those who are required to pay the subsidy, and that's only permitted when it serves a compelling state interest that cannot be achieved through means less restrictive of associational freedoms, the exacting scrutiny standard. And second, the fees are a necessary incident of a larger regulatory purpose, which justifies the required association. So although this case may not seem that it has a lot to do with mandatory bars, it did make it clear what the level of scrutiny is, and the court does seem to have a lot more clarity about that going forward. I don't know if I put their exact holding in your slide, but they said we need not enter into this controversy, the controversy about what level of scrutiny is involved, because we find no basis under any of our precedents to sustain the compelled assessments sought in this case. But then they go on to say, we conclude, however, that the mandated support is contrary to the First Amendment principles set forth in cases involving expression by groups, which include persons who object to the speech, but who nevertheless must remain members of the group by law or necessity. And they cited Abood and they cited Keller. All right, next slide. All right, so we have another 20-year gap. And then we have two decisions within 2 years of each other, where Justice Alito is on a campaign against the Abood case. He becomes increasingly critical of the Abood decision and the analysis in it and the reasons that are supporting it. So this first case, Knox, was a case, it was a teachers union that sent out the required notices about what they call agency fees. So people who do not join the union, these teachers who do not join the union, are still required to pay what's typically called an agency fee. So they have to pay the portion of the union dues that is related to the, that is germane to the collective bargaining work that the union does. So they have to do that anyway. And so they're required to send out a notice to everyone so they can figure out what they're going to pay, because they can object to paying the whole thing and then just pay the germane piece. I'm assuming that sounds a little bit familiar, sounds a bit like Keller. But in this case, there was, during this same time, several ballot measures in California that the union found to be very concerning to their continued existence. And so they sent out another notice increasing the agency fee based on what they called an emergency temporary assessment. And they said they were going to use those fees for a broad range of political expenses and get out the vote activities in California. They didn't offer another chance for people to opt out and to pay just the germane part, even though it seemed clear that zero of it was going to be germane to collective bargaining. So the several of the petitioners filed a class action suit on behalf of 28,000 non-union employees who were forced to contribute money to what they called a political campaign. Interestingly here, so after cert was granted, the union did go ahead and they sent out a new notice. They allowed time for the objection and they sent refunds for the objectors. And then they quickly filed a motion for dismissal because the case was moot. The court didn't buy that. So the court went ahead and found that it wasn't moot and that it could go on. But as you can see, Justice Alito is already saying, so the acceptance of the free rider argument as a justification for compelling non-members to pay a portion of union dues is an anomaly. Okay, we've allowed it, but it is an anomaly. We've tolerated this impingement on people's rights. So he's clearly not being happy with Abood's analysis. And this case, again, is clear about exacting scrutiny being the requirement in these instances, and it's not clear that Abood meets that standard. So that's probably all we need to know. Go on to the next opinion, or the next slide, sorry. So 2 years later, another case, Harris versus Quinn. So this case is essentially a request to extend, at least it was talked about as a request to extend Abood to personal assistance. So in, I think it was Illinois at this time, they had a program where people who needed personal health assistance could hire them on their own. So the individual clients hired, fired, trained, and disciplined these personal assistants, but they were paid by the state. And there was a specific state statute that allowed these personal assistants to join the union, essentially to prevent the free rider problem. The union did enter into a collective bargaining agreement that had one of these agency fee provisions requiring all of the personal assistants to pay the agency fee. A group of them sued, claiming that that violated their First Amendment rights. The district court affirmed, the district court dismissed the case, and the Seventh Circuit affirmed based on the Abood decision. So in this decision, Justice Alito again walks back through, listen, Abood is an anomaly. This free rider thing is typically an insufficient reason to overcome First Amendment objections. And then he starts walking through even more criticisms of the decision. He says Abood seriously erred in relying on Hansen and Street, the two railway cases, as having all but decided the constitutionality of compulsory payments to a private sector union. Street wasn't even a constitutional decision. And Hansen disposed of this critical First Amendment issue with one single sentence that the author later abandoned. So on and on, more and more criticism of Abood. It says Abood misunderstood the holding in Hansen, failed to appreciate the difference between speech involuntarily subsidized by dissenting public versus private sector employees. That, I think, is an echo back to the very first case where, you know, the way unions are working in public versus private employment circumstances are changing over time. And the court is starting to look at that again. So here the court did not extend Abood and specifically called, sorry, losing my place, called into question Abood, but did say in its decision that the respondents here had contended that if the court refused to extend Abood here, that might call into question the KELLER decision. And the court was clear that that was not true, that the portion of the rule that they upheld fit very nicely with KELLER, and that it's completely wholly consistent with KELLER. So at least here we have the US Supreme Court defending KELLER. In the dissent, which was joined by 3 additional justices, there was a defense a little bit of Abood. All right, next slide. So now we get to JANUS, which again, I think you're probably very familiar with. But again, it's Alito. And so nobody's too shocked when actually he gets his opportunity and he goes for it and Abood is overruled. And so this was, interestingly, a lawsuit that was filed initially by the governor of Illinois. And then Mark Janus and I think a couple of other employees moved to intervene. And it was because they didn't even like the positions that the union was taking on the collective bargaining contract. They believed that the union was not paying enough attention to the current fiscal crisis that was existing then in Illinois, and they didn't want to be even paying for that. And these were non-members of the union that were required to pay for the germane collective bargaining activity of the union anyway, because of this free rider issue. And so the court is very clear. So Abood's line between chargeable and non-chargeable union expenditures has proved to be impossible to draw, and even union speech germane to collective bargaining is overwhelmingly of substantive public concern, at least in the public arena. And then developments since Abood was handed down have shed new light on the issue of agency fees. No reliance interests on the part of public sector unions are sufficient to justify the perpetuation of the free speech violations that Abood has countenanced for 41 years. Abood is therefore overruled. So I was thinking about actually reading to you the first two paragraphs of the decision, because they kind of lay out pretty clearly what's going on there. I think I will, and then we'll discuss the rest of it quickly. So the first two paragraphs of the JANUS decision are: under Illinois law, public employees are forced to subsidize a union even if they choose not to join and strongly object to the positions the union takes in collective bargaining and related activities. We conclude that this arrangement violates the free speech rights of non-members by compelling them to subsidize private speech on matters of substantial public concern. We upheld a similar law in Abood versus Detroit Board of Education, and we recognize the importance of following precedent unless there are strong reasons for not doing so. But there are very strong reasons in this case. Fundamental free speech rights are at stake. Abood was poorly reasoned. It has led to practical problems and abuse. It is inconsistent with other First Amendment cases and has been undermined by more recent decisions. Developments since Abood was handed down have shed new light on the issue of agency fees, and no reliance interests on the part of public sector unions are sufficient to justify the perpetuation of the free speech violations that Abood has countenanced for the past 41 years. Abood is therefore overruled. So, didn't bury the lead. So the case does again talk about levels of scrutiny that are appropriate. It goes through and talks about the two decisions that we just went through. Talks about mostly exacting scrutiny. It talks about that level is less demanding than strict scrutiny, but it doesn't really make a decision to change the level of scrutiny. It sticks with exacting. So it does say, though, that picking up on the clues in Harris, the petitioner in the present case contends that the Illinois law at issue should be subjected to strict scrutiny. But the decision finds that that isn't needed to be decided because it can't meet the exacting scrutiny. So the court didn't necessarily increase the level of scrutiny, but it's just a bit murky actually about what the court is actually meaning there. And again, exacting scrutiny means that the compelled substance subsidies have to serve a compelling state interest, and that cannot be achieved through means significantly less restrictive of the associational freedoms. There was a dissent there that defended Abood and was just like, excuse me, but not a decade ago, this court unanimously called the Abood rule a general First Amendment principle. Well, next slide. Next slide. Oh, sorry. The Ninth Circuit cases, right. So, sorry, I'm missing a little bit of my, my printer did not exactly print out everything I needed. So I just included these two. These are the two cases against WSBA that raised these same issues about whether Keller survives, whether Lathrop survives. And they've both been dismissed by the Ninth Circuit. So not that we need to discuss them. I just wanted you to know that we too have been the subject to some of these. Okay, the next slide. All right, so I think you've all been aware that we've been talking for a while about after JANUS was filed and decided, because it overruled Abood, and because, as we just went through, Keller's analysis and whole structure of how things should be done was based on Abood, there was a lot of question about whether JANUS actually overruled Keller. JANUS didn't mention Keller. It was mentioned in the dissent just as a concern. Hey, you know, majority, you made this decision and this might affect integrated bars, and also I think it's student university organizations that engage in speech activities, but the majority didn't pick it up. So as you can see, there have been cases in the 5th, 6th, 7th, 8th, 9th, and 10th Circuit. And I tried to put in this slide for you where they are. In the 5th Circuit, there are cases filed against the Louisiana and Texas state bars. Interestingly, their appeals were argued on the same day. I'm not aware of any decision yet. The Michigan case in the 6th Circuit, their briefing is completed. And I will say that, so the many of the oral arguments for these cases are available. You can get them and listen to them if you're interested. But as you can see, there are quite a few. Oregon actually had two. There was Crowe and Gruber, and we'll talk about that. They were combined for the 9th Circuit. I have a little asterisk on one of the Wisconsin cases. And I'm trying to find the language of that. So I think that there was a dissent to the cert denial in that case that was written by Justice Thomas and joined in by Gorsuch. And some of the language in his dissent was petitioner's First Amendment challenge to Wisconsin's integrated bar arrangement is foreclosed by Keller, which this petition asks us to revisit. I would grant cert to address this important question. Keller was an extension of Abood. Our decision to overrule Abood casts significant doubt on Keller. The opinion in Keller rests almost entirely on the framework of Abood. Now that Abood is no longer good law, there is effectively nothing left supporting our decision in Keller. If the rule in Keller is to survive, it would have to be on the basis of new reasoning that is consistent with JANUS. We have admitted that Abood was erroneous, and Abood provided the foundation for Keller. In light of these developments, we should re-examine whether Keller is sound precedent. So again, that was in a dissent to the cert petition, but I just wanted to highlight for you that these issues just continue to be raised. Okay, now next slide. Okay, finally we get to Crowe. And I was hoping that by going through the history that you would be able to appreciate why this case might be important. So, and to set up what might be significant about the Ninth Circuit's decision on this free association claim. So I think you know the facts because we've discussed them before, but in April 2018, the Oregon State Bar Bulletin published 2 statements relating to white nationalism and normalization of violence on adjacent pages in their magazine. One of those statements was attributed to OSB and signed by its bar leaders. The other was a joint statement of the Oregon Specialty Bar Associations. The opinion actually includes the full language of both statements, and the opinion is in your materials. The Oregon State Bar maintained that both statements were germane to its role in improving the quality of legal services, but it provided a $1.15 refund to members who complained about that statement. Next slide. Next slide, Rex. So the plaintiffs alleged, these were 2 cases that were combined for appeal at the Ninth Circuit. So the plaintiffs, they both alleged that the 2 statements in the bulletin, both of them were not germane, that compelling them to join and maintain membership in the Oregon State Bar violated their right to freedom of association, and compelling them to pay annual membership fees without prior affirmative consent violated their right to freedom of speech. Gruber only claimed that Oregon State Bar's Keller procedures were deficient, and Crowe only claimed that the Oregon State Bar is not entitled to sovereign immunity from suit. Next slide. So there's the procedural history that I think we've sort of talked about. So initially the case was referred to a magistrate who recommended granting Oregon State Bar's motion to dismiss and denying the Gruber motion for partial summary judgment. The district court adopted the magistrate's decision and dismissed the cases. Both plaintiffs appealed and the cases were consolidated at the Ninth Circuit for hearing. Next slide. So the case did 3 things, 2 of them that are sort of important for today's discussion. First, it affirmed that Keller plainly has not been overruled. So, they're not reconsidering the free speech portion of the First Amendment issues, but they say plaintiffs claimed that requiring membership in the Oregon State Bar to practice law violated their freedom of association under the First and 14th Amendments because the Oregon State Bar engaged in non-germane political activities, such as publishing the 2 pages of the bulletin. The court, the Ninth Circuit decision found that the plaintiffs raised an issue that neither the Supreme Court nor we, the Ninth Circuit, have ever addressed, which is, and they described it as whether the First Amendment tolerates mandatory membership itself, independent of compelled financial support in an integrated bar that engages in non-germane political activities. So I think that statement of the issue is perhaps and maybe is meant to be outside of the decision of Lathrop, which was financial support for group speech, and also outside of Morrow. And the court in the decision does say that the Morrow plaintiffs pretty much raised the same issue, but that the court, when it decided the case itself, restated and narrowed the issue. So Morrow should be interpreted to be the same as Lathrop. So this case concluded that there is this undecided issue about whether there is a broader First Amendment issue here than was decided in Lathrop. Rex, I can't remember if this is my last slide. Can you see if there's a next one? Okay. Yeah. So here, so what happened is the court remanded this issue and said, the court on remand is going to have to decide, number one, whether JANUS supplies the appropriate standard for the free association claim. And if so, whether the Oregon State Bar can satisfy the exacting scrutiny standard. So, whether the Oregon State Bar can satisfy a standard of showing a compelling state interest and least restrictive means. So is an integrated bar, potentially the issue is an integrated bar the least restrictive way of satisfying the compelling governmental interests of regulating legal services? And then they say, also, given that we've never addressed this before, the court's going to have to maybe determine whether KELLER's instructions about germane and not germane and the procedurally adequate safeguards, whether they apply to the free association inquiry. And then the last thing about the Crowe decision that I want to make sure you are aware of is that in the dissent says, we are remanding plaintiffs' free association claim, and if on remand they prevail on that claim, the bar will presumably need to change its bylaws and maybe its entire structure. Because such alterations would likely change the procedures the Crowe plaintiffs currently challenge, I don't think it is necessary that we review those procedures at this stage. So I think that points out what the potential ramifications are if on remand this is decided, I guess, in the same way the Ninth Circuit decided it. Okay, now I've talked at you for 45 minutes. Sorry for the length of the presentation, but I'm hoping it was helpful.
Thank you, General Counsel Shanklin. One question from me, and maybe there's some questions from other governors, that what I don't understand quite and not getting my head wrapped around is how Lathrop is different than Crowe. What is the larger issue, broader issue, I guess is what they say, in Crowe that was not decided in Lathrop? It seems to me it's compelled financial support of speech, but apparently there's something that I'm missing there.
Yeah, and I don't know what the answer is. If I had to speculate, I would say what they're trying to get at is, regardless of any money paid, just compelled association with an organization that takes positions on political issues. So I think they're trying to make it broader than just financial support. And so the only way I can think about that is if it's broader than financial support, leave the financial support to the side, and it would just be simply being a compelled membership in an organization, one of the organization's directions is to engage in speech.
I still don't understand. I still can't figure out in Lathrop how that was any different, because I imagine the Wisconsin Bar Association was engaging in some kind of political speech then. So it's just beyond me. Governor McBride.
Thank you, Mr. President. No, I think Julie's on to it. That was my question too. Why is this different than Lathrop? But I think the finances kind of obscure the issue the court wants to address, because most of what you pay in dues goes to regulating the profession, improvement of the practice of law, discipline. In some ways, all those legitimate purposes that we all know is most of every penny that a member spends to the Bar Association kind of obscured the issue of just the association. So I think that's the right line. And it's curious that they want to break that apart. But I think that's why.
Yeah, and I don't know if they want to break it apart, but part of what the court has done recently is to attack the free rider idea as being important enough to overcome the potential constitutional infringements. And so maybe that's a way also to think about it.
Governor Stevens.
Yes, thank you. Julie, when you were answering Kyle's question and you mentioned the whole issue of political speech, which, for me, I'm always wondering, so what is political and what isn't political in terms of anything we do, even in terms of going to the legislature? But one of the qualifiers that you didn't use, but I'm curious about, is germaneness. And, at least some of those lines seem to talk about activities that are germane to the whole mission of the association or the entity versus just political.
No, I think you're onto it exactly there. So I kind of left that issue to the side so that I wouldn't talk to you for 3 hours about old constitutional stuff on a Saturday morning. But yeah, there have been decisions since Keller that have said specifically, look, the focus really is on the compelled license fees should be used for things that are germane to the purposes of the integrated bar, which makes complete sense because that fits with the exacting scrutiny test, right? What is the compelling state interest? And I think you're right. The compelling state interest, well, it probably isn't taking political positions. Like that's not what justifies having an integrated bar. But yes, the focus of the analysis, rather than on picking out the word political and picking out the word ideological, which the court has said several times, okay, that didn't work very well, right? That's kind of what I think they said when they blew up a bood. That more so the focus is on, just the same as in the union context. You are permitted constitutionally to use compelled fees for the purposes that justify the compelled association. So yes, I think that's right.
And can you tell us where we are both in terms of whether Oregon is at least considering an en banc hearing, and also to whatever extent or when or if we might be asked to submit an amicus?
Yeah, I don't have an update from Oregon. If I do, I will be providing you that information.
Any other questions for General Counsel Shanklin? Governor Peterson.
Well, first of all, I'd like to thank the Oregon State Bar for showing us something that could potentially get us in trouble. So I think we all appreciate that. When I did read the case, it was interesting because, you know, the first paragraph of the State Bar's comments and the last paragraph of the State Bar comments seem to be done in a way that they could have potentially avoided this lawsuit. Some of those middle paragraphs, I suspect, is what may have caused them to get into this lawsuit. And same thing with other organizations. The first paragraph they did, I thought, was really done well, and it tied to law and justice and the legal system. And their last paragraph in their statement, I thought, was really well done in terms of tying it to law and justice. Once again, I think that from the organizations and the State Bar, it does appear to me they went off track in those middle paragraphs. So I hopefully we've sent this to our Bar News staff and board and doing things to hopefully prevent us, being involved in an expensive lawsuit. Thank you.
Just a comment on that. The primary problem with in my opinion, the two statements were not necessarily the bar statements. It was more the specialty bar associations and the alignment of the two statements, which made it appear to be much more political than it otherwise would have been. And that's been the discussion in Oregon about, what could we have done better? That was one of the primary things that they thought was a mistake. Governor Abel.
Well, thank you, Mr. President. And as an initial matter, I want to thank General Counsel Shanklin for the presentation. This is stuff that I could nerd out on all day, so I've really appreciated it. Thank you. Two real comments, I guess, in light of the presentation we've just heard. One is I don't want us to miss the forest for the trees here, in the sense that regardless of whatever the ultimate outcome is of the Oregon litigation or related litigation, that we're talking about constitutional values that are in play here. And this is, I think, part of the reason why our members and the members of the bars involved in the states with the related litigation are so passionate on these issues. So that's something that I think is first and foremost to keep in mind. And then the second piece is that I hope this presentation is kind of firing the thought processes of all of our members as well as our board members about what is the ideal structure of our bar association as we go forward further into the 21st century. And I realize that's separate and apart from a strictly constitutional analysis, but what is the best form of structure for this organization? And that's probably a conversation for another day or a number of other days, but I'd like to lay it out there for people to think about. Thank you, Mr. President.
Thank you, Governor Abel. All right. Any other governors have any questions, comments? And hearing Governor Abel, your hand is still raised, so I'll ask. All right, not seeing any, I'll open this up for public comment. Ms. Hawkins.
Yeah, but I hope we're not going to start talking about alternate structures again, because we went through a long process led by then Chief Justice Fairhurst about the structure of the Bar Association. We heard from a lot of people around the country and reached the conclusion that we should maintain our integrated bar status, and that it was likely that down the road, more distinctions would be made between unions and bar associations. And that still, to me, seems to be likely. Unions are generally viewed as pro-democrats. Bar associations are largely viewed as more conservative and more Republican if you look around the country. And there was also the mention that it was likely that most of the justices of the Supreme Court had probably extensive involvement with their local bar associations in their own states, and they might be more reluctant to overturn a bar association structure. So I hope we're not going to try and redo something that was done extensively not that long ago. I think there's been fear of these cases for a long time, and yet here we still are. Nobody has ripped apart the Oregon State Bar yet, and it would be very distressing to think that taking a position against white supremacists would somehow be viewed as some sort of mistake. But there are reasons to fight for having an integrated bar. We are a bunch of lawyers and we know how to fight, and we should continue that path.
Thank you, Ms. Hawkins, Governor Abel and Governor Clark and myself, and former Governor Sweigel, who's joined us for the next discussion topic. We all remember the structures work group and remember the work that we did there. I think we're in now a state of monitoring, and if things come later on through the court system and we need to take action and we need to look at it, we're going to bring back all of that experience of the structures work group, and we'll have to be figuring out what our next step is. But that's the purpose of these updates, not necessarily to take action now, but certainly be ready if we need to in the future. Okay, I don't see any other hands, virtually or otherwise. And so thank you, General Counsel Shanklin, for that in-depth analysis of the case law. And we'll continue to monitor the situation and provide updates as needed. Let's take, let's see, what time is it? It's 10:57. We can take maybe a 10-minute break till 11:05, and then we'll come back and we'll start on our next discussion topic with our guests. Thank you.